in the name of family law.
Good morning. I'm here with Kent Wood, who's the owner and lead attorney at Wood Associates. That's a firm in Lansing that specializes in family law. Welcome back, Kent.
Oh, thank you.
So, what is your approach when a new client walks into your office with a family law case?
Well, when a new client walks in, we like to kind of get to kind of our process, our, philosophy. I often tell clients that we strive to protect your best interest from its three greatest enemies: others, the government, and your emotions. And kind of to drive home that point that there's a lot of things that are affecting your decisions that are outside of your control. And when we talk about others, we're usually talking about the spouse, significant other, whoever we had a child with. When we're talking about the government, it could be the court we're referring to, it could be Child Protective Services, it could even be school, right? And then when we talk about your own emotions, we're just talking about all the anger, frustration, anxiety related to this kind of a lot of people first time ever in courts experience. And we try to address this by educating clients about the whole process and about how to really approach dealing with the other side. In these relationships, there's a point where there's trust, right? And then something happens and the trust breaks, and now you've got to work with someone you don't trust to raise a child in some point. And sometimes we refer to this as a battle or as a war, and it comes down to what I always call a battle of reasonableness. You have to be reasonable. When we talk about emotions, I tell my children, you can't control your emotions, but you can control your actions and your responses to other people's actions. And so that's what we focus on. What can we control? And there's a lot of times, for example, someone doesn't show up for parenting time, right? You miss Thanksgiving, or you're supposed to have a phone call with somebody and it doesn't happen and they fall apart. I always say, well, what's the reasonable response? Is there something reasonable to do that? You can't yell at that person. That's not going to change anything. We also talk about how you had a relationship, somehow had a child with somebody, and that person could have been, let's say it could be a jerk, disrespectful, lying. Mm-hmm. Just because you're in a court battle, all of a sudden, they're not going to stop being that way. And so we try to prepare everybody to understand how they should be reacting to all of these things, and that's what we focus on. We focus on our clients' needs.
So it sounds like it's great when both sides are being reasonable. How often does that happen?
Well, that's rarely. Unfortunately, a lot of people come in thinking it's going to be reasonable to start, we're going to get along, and then the lack of trust that was there flares back up, and then it kind of breaks down and becomes argumentative and contentious.
So, how do we get the people out of this situation? How do we get both sides to be reasonable?
Well, the good thing about the court process is you end up with an order, and everybody has to follow that order. They're not going to always follow that order, right? People are human. They're going to, their own emotions, just like your emotions, are going to dictate some decisions they make. So remember, always be reasonable. You can always enforce the order. And I try to have clients focus on, you can't stop somebody from being disrespectful, but you can ask them to follow an agreement that they've either agreed to put in place by consent, or the court has decided this is what the rules of the game are going to be, and to stick to that.
Well, let's talk about consent orders. So, and getting parties to settle their cases so they don't have to go through the whole court process.
Right. So a consent order is the idea that we have major issues, and usually it's custody, parenting time, support, and division of property. But specifically with custody and parenting time, it's always best if you can consent, because it's a schedule that works for everybody's schedule. Because even as when you're together, you're raising kids, but you're living a life and work and all that outside of that. When you're separate now, you're raising kids separately, but you still want to live a life and everything outside of that. So a consent order allows the parties to put together or craft something that's unique to them, where they get to truly decide what's going to work for their schedules. As opposed to where the court orders it's something, and there's usually just set things in place that the court has. They have standard parenting time schedules.
Right. So when parties can settle or mediate and come to an agreement together, maybe neither of them love it, but it's something they can live with. Then let's talk about what happens when the judge decides who's going to have custody or what the parenting time schedule is.
Well, when it comes to the judge deciding, I always kind of warn clients that, look, you lived with this person. You know this other person intimately. The judge is kind of coming in, and it's a snapshot look of what's going on. He doesn't know every little detail. He's not going to know. When I say he, it could be a female judge as well. But they're just not going to know. And so they're making decisions based on this summarized, idealized version of what's going on, and trying to see through who's been credible. who's been, or I like
Who
to
do
tell
they believe?
Right, who do they believe, who's been the most reasonable in terms of interacting through the whole process. And then that decides, and so they may get it wrong, they may get it right, but that's what you have to do if you don't consent.
You made a very important comment about being reasonable, because it's in your client's interest to be reasonable even when the other side's not being reasonable, because that reasonableness can be used to their benefit when you're presenting your case to the court, if it has to go that route, right? And used to their, hopefully the judge looks at the fact that one party's being reasonable and is more considerate of their needs because of their willingness to be reasonable. That's what it sounds like.
Oh, definitely. I think it also comes down to one of two things happens when you're being reasonable. One, the other side starts being reasonable and everything just kind of works out.
Clicks together.
Or you got an order and now it's going to benefit you in the court.
And I think it's important to note that oftentimes when the judge has to have a trial and make the decision, one party's going to be unhappy, usually.
Oh, definitely.
It's then we're having to say, instead of you guys agreeing and coming up with a solution that you both can live with, one party might be very happy with that decision and the other party is going to be very unhappy with that decision. Right?
Oh, yeah, most of the time there's usually really one unhappy person. Usually when there's a consent, everybody kind of walks away and goes, I can live with that. But when it's the judge deciding, somebody usually storms out of the room upset and frustrated.
So let's talk about high conflict cases. So, we've been talking about just regular cases where parties can't get along, but there's other cases that take it to another level, I guess, the high conflict custody cases.
When it's high conflict, it really comes down to, what we provide in terms of service as attorneys in general is you've got to have the evidence. You've got to produce different documents and stuff, and you got to focus on those things, because if court sees two people just yelling at each other and calling each other names, they're going to ignore both of them and just do what they think's best. You got to really kind of bring that part back, be kind and considerate, even when you don't feel like it, right? Again, actions over feelings. And then that'll help you put together an argument that the facts demonstrate what's going on, not the emotions.
Right, and in the high conflict cases, aren't judges often ordering psychological evaluations and making all other kinds of professionals come into the case, which of course is costing everybody more money, causing more delay?
Oh, definitely, and there are times where there's need for that, when there are true facts demonstrating one parent is having a struggle with some kind of substance or gambling or something like that. But sometimes it's just because it's so conflict and they can't decide, they have to bring in experts. Experts take time, experts take money, and delay the whole process. The process that's taking about a year now could become a process that takes 2 years. Mm-hmm. And nobody wants that uncertainty, especially when their children are only with them for 18 years of their life.
Right. And during this whole process, where are the kids? Is there some sort of temporary order in place that tells the parents what happens while they're waiting for this long court process to finish? Oh,
yes, definitely. The court always puts in some kind of temporary pending order early on, as fast as they can. Sometimes that's not super fast, but everybody wants that quickly. That usually takes about 4 to 6 weeks to really get that finalized and worked out. But there will be a temporary plan in place, but that could just cause more and more problems. The sooner you can get to a final plan is always best.
Right. Well, thank you for these insights. Very helpful.
Thank you.
In the Name of Family Law is brought to you by Wood & Associates, PLLC.